Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 103. We've two EAT cases in this episode and one employment tribunal case, and as a bonus there's a film review for sticking with me to the end of the episode. As usual, please don't forget you can access the podcast via iTunes. It's on the Mayor Brown internet and YouTube, and the Twitter feed Nicholas Robertson at Nicholas Robber, R-O-B-E-R, that is, and then the number one, which is also where we post out links to all the cases that we've discussed during the podcast. Well, first case up, Glasgow City Council and Dehann. I want to start with this case. It's an EAT decision about a tribunal's ability to scrutinise the validity of a settlement agreement. As we all know, under Section 203 of the Employment Rights Act, there are various statutory formalities for a binding settlement agreement. It must be in writing, it must relate to a particular proceeding, and the individual has to be advised by an appropriate independent advisor. It's also necessary for the agreement to record that the conditions regarding settlement agreements are satisfied. Well, those are the statutory formalities. What else is required? The underlying facts here were that the claimant, who was a teacher employed by Glasgow City Council, brought discrimination claims against the council. There was a settlement ahead of the main tribunal hearing. The claimant, on that basis, wished to withdraw his claim, and that's precisely what happened. However, some 3 weeks later, the claimant wrote to the tribunal saying he'd lacked the necessary mental capacity to instruct his solicitor and to make decisions at the time of the alleged settlement. He applied for reconsideration of the tribunal decision, which dismissed his claim, and he claimed on that basis that the settlement agreement should be set aside for his lack of mental capacity. The tribunal held a preliminary hearing to determine whether or not it had the legal ability to set aside an agreement on the grounds of lack of capacity. And the background to this is that in a case called Industrious Limited and Horizon Recruitment and others, in that case the EAT eventually had to look at a settlement agreement which it was alleged had been entered into on the basis of a misrepresentation made by the employer to the employee. Under normal contractual principles, a contract entered into on the basis of misrepresentation may be set aside. However, here, in this case, the EAT describes the Dehann case as raising a novel issue, i.e. whether or not a lack of mental capacity, rather than a misrepresentation, enabled the tribunal to set aside a settlement agreement. The Employment Tribunal ruled it did have jurisdiction to set aside the agreement. Mr. Dehann had not had the mental capacity at the time that he took the decision to enter into that settlement agreement. The council appealed, but the appeal was unsuccessful, and the council argued that this case was different from the Industrious case. First of all, this case related to mental capacity to enter a settlement rather than there being an absence of agreement through an essential error or a misrepresentation. However, the EAT simply refused to accept this was a valid distinction. The council also argued that because this settlement covered all claims, including claims over which the Employment Tribunal had no jurisdiction, it could not set aside the entire agreement. The EAT again took the view that this was not correct, but acknowledged there might be arguments about whether or not other claims outside the tribunal forum had been settled. In other words, they said it was possible that claims outside the Employment Tribunal could be caught by the doctrine of res judicata. So that would seem to me to indicate the agreement, which is voidable under English law if the lack of capacity is shown, might still have some impact, which I'm not quite sure how that would work. Anyway, clearly one doesn't come across these sorts of cases every day, but we've certainly done a couple of cases where settlement agreements were concluded with individuals who were known or believed to have alcohol abuse issues. Similarly, individuals who are very ill but with whom the employer looks to enter a settlement agreement might also be particularly vulnerable or lack the ability to enter into the settlement agreement itself. I think this is probably one of those areas where as a lawyer you need to tread carefully. Certainly if you're acting for a claimant in those circumstances, you're going to want to go the extra mile to ensure that you are satisfied you are receiving proper instructions. In the matters we've dealt with, which were for the respondent, sometimes we've made sure that the amounts payable by the employer for the employee's legal fees when they're entering the agreement are significantly increased, so there can be no suggestion the employee was denied full and proper representation for lack of finance, and therefore, we would hope, it's more likely that a settlement agreement would stick. So, that's the case of Glasgow City Council and Dehann. Next up, Buchanan and the Commissioner of Police of the Metropolis. This is a case on the interplay between the disability discrimination legislation and a sickness absence policy. Although the case itself concerned the police performance regulations, it has a rather wider impact than that. The background is the claimant started work for the police in 1995 and in 2012 was involved in a serious accident from which he ended up developing post-traumatic stress disorder. So he qualifies as a disabled person. Well, the relevant police force had a procedure for managing long-term absence called the unsatisfactory performance procedure, which I think we can agree is a pretty unfortunate name because it covered non-attendance at work through sickness and injury as well as failures of performance. The underlying regulations provide for a three-stage process, and that was what was adopted by the police. And things like where a meeting is called which finds that performance or attendance has been unsatisfactory, there has to be a written improvement notice served on the individual as a follow-up. The Tribunal noted that both the police procedures and the underlying regulations made no allowance for disability, but, crucially, although the police regulations talked in mandatory terms, i.e. Stage 1 will be followed by Stage 2 if performance remains unsatisfactory, etc., they contained provisions for managers to postpone or adjourn a meeting to a later date, so that matters did not necessarily need to proceed beyond the first stage. As I will explain, that became crucial to the outcome. The AT also pointed out there was a discretion as to whether or not to begin Stage 1 at all. The officer claimed that in this procedure, Stages 1 and 2 of the procedure had been gone through with him and should not have been applied, and this amounted to discrimination arising from disability. I would add in passing, he wasn't in fact actually dismissed because before it got to Stage 3, the final stage, he was allowed early retirement. But, nonetheless, the case proceeded because he claimed disability discrimination under Section 15 of the Equality Act 2010, i.e. that he'd been treated unfavourably because of something arising in connection with his disability, and the treatment was not a proportionate means of achieving a legitimate aim. The Tribunal accepted he had been treated unfavourably and appears to have assumed that this amounted to a detriment, and this point wasn't challenged on appeal. The question was whether it was justified. More particularly, the question was what had to be justified. Was it the sickness absence policy itself with its various stages and the need to have written notice which was to be justified, or was it the application of the policy to the individual which had to be justified? The respondent in this case relied on the earlier case of Selden and Clarkson, Wright and Jakes. There, if you remember, the individual was a partner in a law firm which had a mandatory retirement age clause. In the Selden case, the Supreme Court accepted it was the rule that had to be justified rather than its application to the claimant in that case. In this case, the Tribunal found it was the policy which had to be justified rather than its application, and that it was proportionate to apply the policy because the policy was there to manage attendance effectively. Perhaps unsurprisingly, the claimant appealed. Well, the AT pointed out it was necessary for the employer, or in this case the police force, to show that the treatment of the claimant was a proportionate means of achieving a legitimate aim. It was therefore necessary to look at what the treatment was. The AT accepted that there could be cases where the employer's treatment of the employee is the direct result of applying a general rule or policy. In that case, whether or not the treatment is justified will usually depend on whether the general rule or policy is justified. The Selden case, they said, was an example of that. The claimant in Selden was required to retire when he reached the age of 65 in accordance with the term in the firm's partnership deed. It did not have to be justified in relation to a particular case of the claimant at the time. There was a general rule with a mandatory impact. In Buchanan, there was an attendance management policy and there was no such direct result. Generally, as the EAT correctly pointed out, attendance management allows for different responses to individual circumstances. Therefore, the AT said, the focus moves to the treatment of the individual rather than the underlying policy. All in all, the AT allowed the appeal, remitted the case back to the Employment Tribunal to reconsider the treatment of the individual in this case, which obviously looks to be a rather more difficult thing to justify, rather than the policy, which clearly had sensible aims and objectives. So, Why is the case important? Well, I think it would have been easy to have been misled by the Selden case on the need to justify individual treatment rather than the rules. And I think this EAT decision highlights a useful distinction. If you have a mandatory rule which provides for a particular outcome, then it is the rule itself that has to be justified, including perhaps whether or not there should be more discretion built into the application of the rule. However, if you have a process which allows for managers to evaluate and take decisions from a range of options, then clearly what you need to justify is the decision which the manager took. This is particularly relevant in relation to absence management and disability discrimination, because there's often a range of options available for a manager, but it's not a case of testing the employer's response by a range of reasonable responses. The course of action, the treatment, has to be objectively a reasonable one. So that's the case of Buchanan and the Commissioner of Police. Final case, Snell and Network Rail Infrastructure Limited. This is a decision of the Glasgow Employment Tribunal. I don't tend to feature a lot of employment tribunals in this podcast because, of course, they are of pretty limited impact generally, as they don't create binding precedents. Every now and again, though, a case will come along where it may be a particular unusual feature, or it's the first in what is undoubtedly likely to be a series of cases like to go through the appeal courts. So it's of interest the way in which the first court addresses matters. Here, my reason for including it is slightly different. It's been reported in some areas as a particularly significant case. Indeed, we had clients approaching us asking about updating some advice that we'd given earlier. But when you analyse the case, it's not that earth-shattering. But I think it's worth walking through the case to explain quite why that is. The background is the claimant was awarded not far short of £30,000 for discrimination, contrary to Section 19 of the Equality Act 2010. Claimant asserted that both he and his wife, who, coincidentally, worked for Network Rail, although that wasn't relevant to the outcome, were entitled to shared parental leave and shared parental pay. However, under the Network Rail policy, the shared parental pay provided to fathers under their family-friendly policy was to provide statutory pay only, whereas the women, who of course were giving up their outstanding right to receive maternity pay at that point to enable their partners to take parental leave, the women, if they took shared parental leave, would receive pay at the higher rate equivalent to enhanced maternity pay. So, in short, a woman taking a shared parental leave period, who was the mother, would receive pay at a higher rate than the father of the child taking shared parental leave. Unsurprisingly, the claimant, the father in this case, asserted this was both direct and indirect sex discrimination. Under the family-friendly policy document put out by Network Rail, it clearly said that, quote, for mothers, primary adopters and first surrogate parents, unquote, they would receive 26 weeks shared parental pay, paid at full pay, inclusive of statutory shared parental pay, before moving on to statutory shared parental leave rates only, unquote. For, quote, partners, secondary adopters and secondary surrogate parents, unquote, it was statutory shared parental pay all the way through. The claimant, according to the case report, seems to have laboured long and hard to get Network Rail to listen to him, and he pointed out that BIS had produced a note which said where you had a mother and father on shared parental pay, you couldn't treat those individuals on shared parental pay differently by virtue of their gender. Similarly, ACAS had provided guidance which stated, quote, the important thing is that, within a shared parental leave scheme, men and women are treated equally and are paid at the same rate in the same circumstances, unquote. Network Rail failed to respond to a number of communications he sent, and the grievance hearing took a long time to organise, not least because the manager concerned felt he had no authority to change the relevant policy. Eventually the grievance was turned down, the employee's appeal was turned down, and matters went through to a tribunal hearing. The respondent attempted to justify its policy on the ground that there was a need to encourage the retention of women in a workforce which was male-dominated. However, Network Rail appealed to have decided that argument had no realistic prospects of success because it was abandoned and liability was admitted, leaving the tribunal to set the remedy, and that was all. Network Rail had, however, successfully convinced the claimant that the case was not direct discrimination because there were circumstances in which a woman could be a secondary parent, secondary adopter, etc. However, Network Rail accepted it was indirect sex discrimination unless it could be justified because the policy of only paying statutory minimum shared parental pay to the, my term, second parent would hit a disproportionate number of men. So, I know what you're thinking. We have a case in the Glasgow Employment Tribunal where the employer didn't contest liability in relation to shared parental leave. Why, oh why, is this case in the podcast? Well, in some quarters the case was reported as addressing a much more significant issue. Since the shared parental leave scheme was introduced, one of the outstanding issues is whether it is possible for a man on shared parental leave to compare his pay not with a woman on shared parental leave, but with a woman on maternity leave. Enhanced maternity pay is a relatively common feature for many employers. Rather few will necessarily offer enhanced shared parental leave pay. If it were possible for a man on shared parental leave to claim a comparison with a female employee on maternity leave, that would be a significant step. However, that is not what this case dealt with. This case dealt with two people who were both found to be on shared parental leave. That finding by itself is quite an odd one, because there was no reason for the woman to be on shared parental leave. She could have stayed on maternity leave for her period of leave and benefited from those rights, but nonetheless, the finding of the tribunal was that she was on a period of shared parental leave throughout. Since the weight of opinion was always in favour of treating men and women equally on shared parental leave, the tribunal's decision, and the respondent's decision to abandon the attempt to justify the differential treatment does not look surprising. Secondly, the law of unintended consequences also applies here. When the case started, Network Rail had a scheme under which women would receive enhanced shared parental leave and men were on statutory minimum. By the time the case was over, Network Rail had levelled down the benefit so that those on shared parental leave are only on statutory minimum pay, men and women. So it's a useful reminder that equality of pay is not about the abstract levels of pay, it's about the comparison the law allows you to make with a fellow employee. I'm not aware of any reported cases dealing with the interplay between shared parental pay and enhanced maternity pay. Equally, one article I've seen makes a very good point that Mrs. Snell was taking 26 weeks of leave and therefore forfeiting 26 weeks of leave to Mr. Snell. Mr. Snell was apparently only taking up the shared parental leave left over after his wife had taken her 26 weeks of maternity leave. Under the Network Rail scheme, the shared parental leave enhancement for women only applied for the first 26 weeks. However, the case seems to have proceeded on the basis that when Mr. Snell took his 26 weeks shared parental leave, it effectively counted as equivalent to her first week of shared parental leave, rather than her 27th week of leave, when she too would have been on statutory minimum pay. Now, that may have been down to the drafting of the Network Rail policy. But I think the point is, if you have drafted a shared parental pay and leave arrangement, it's important to make sure that you clearly identify whether a man who is taking shared parental leave is deemed to be taking it week one onwards in a maternity period swap, or whether his pay and leave notionally kick in respect to the week at which the woman has or will cease to be on maternity leave. So, if in this example, if a woman stays off for 20 weeks on maternity leave, then abandons the remainder of her maternity leave, whether or not she goes on to shared parental leave, and the man then takes up the remaining period, does the man's shared parental leave pay apply as if it was week 21 of the maternity leave period, or is he able to start from week 1? So, that's the case of Snell and Network Rail infrastructure. So, thank you very much for listening, as always. It's been a pleasure. I promised you a film review, didn't I? I went to go and see The Girl on the Train the other day. Now, not having read the book, the plot spoiler, the twist, I should say, was completely unexpected, and don't worry, I've learnt my lesson about from the Game of Thrones apology episodes. I'm not going to reveal anything of the story, but I didn't see the twist coming. I thought the film was very good, and I thought Emily Blunt, it's not a particularly glamorous role, but I thought she was very good too. It's quite full on. It's my brother, who I saw the film with, commented at the end, I don't think there was a single joke in the entire film. No moments of humour. But no, very good film, and thoroughly recommended if you're looking for something to see. So, covering all the bases this week, legal cases and a film review. Stay safe and look forward to catching up with you in a couple of weeks' time. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.